everyone, my name is Darshana Baiju and the topic for my presentation is probation laws in India. Probation serves as a period of supervision over an offender ordered by the court instead of serving time in prison, essentially functioning as a conditional release based on the promise of good behavior. The concept of probation is reformative in nature and aims to prevent the offender from being sent to prison. The Probation of Offenders Act 1958 was enacted keeping in mind the need for reformation and not mere punishment. Probation is particularly used for first time offenders or those guilty of minor crimes. The word probation comes from the Latin word probare, meaning to test or prove, fitting for someone being tested for rehabilitation. Now let's look into the legal framework for probation in India. Probation of Offenders Act 1958. It applies throughout India and allows courts to release offenders after a small warning. Court can order probation with or without supervision. It helps in avoiding stigma by preventing disqualification attached to conviction. Next is Section 360 of CRPC. It is similar in purpose but applicable mainly where the Act is not enforced. It has broader discretion to judges in granting relief. Section 360 of CRPC is not applicable if the case falls under the Probation of Offenders Act. Juvenile Probation System. The Juvenile Justice Care and Protection of Children Act 2000 deals with probation in cases of juvenile offenders. It prioritizes rehabilitation and integration over punishment. The juvenile can be released under supervision or in the custody of parents or guardians. Juvenile probation includes education, vocational training, and psychological support. Maximum duration for juvenile probation is 3 years. Now let's look into the conditions and limitations of probation in India. Probation is not granted in the following cases. First one is offences punishable by death or life imprisonment. Second one is in the cases of breach of trust, forgery, and sexual offences. The court examines the age, character, and circumstances of the offender. Minimum probation supervision period is 1 year, and the courts can impose specific conditions like attending counseling or avoiding specific locations, etc. Compensation and cost. Under Section 5 of the Act, the court may direct the offenders to pay compensation to victims and cost of legal process. In the case Rajeshwari Prasad versus Rambabu Gupta, the court emphasized compensation to the victim as part of justice. It adds an element of restoration justice by addressing the victim's suffering. Reformative and rehabilitative approach. Probation reflects the Gandhian philosophy of forgiveness and rehabilitation. It focuses on helping the offender reintegrate into society instead of labeling them. Rehabilitation includes community service, education, therapy, etc. Courts are encouraged to use non custodial sentences for less serious crimes. And in the case Gulab Singh versus Yuvraj Singh, court favored probation considering the offender's background and potential for reform. Judicial interpretations. Courts have interpreted probation laws to promote fairness in the following cases. In the case Masarala versus State of Tamil Nadu, it was held that age is a significant factor in probation decisions. And in the case Ramamurthy versus State of Karnataka, it was held that good behavior during trial courts is a key factor. In the case Chandreshwar Sharma versus State of Bihar, it was held that the court must justify the denial of probation. Om Prakash versus State of Haryana, it was held that courts can consider post conviction behavior as a factor. Then, in the case State of Karnataka versus Mohammad Nasir, the court warned against excessive leniency and it was held that courts must balance justice and reform. Challenges and future directions. The challenges in current probation laws are insufficient number of trained probation officers, inconsistent application of probation laws across states, and inadequate training and monitoring. The recommendations are to allocate better funding and staff, to create consistent national policies and training for officers, and to engage NGOs for aftercare services and community integration. In conclusion, probation supports a constructive justice model over retributive punishment. It is suitable for less serious crimes, especially for first time offenders. It encourages social reintegration and it supports victims through compensation and encourage societal healing. So, the system must be strengthened to be more efficient and widespread. That's all about my presentation. Thank you for your attention.